In other news, with respect to the case of whether or not women should be allowed on a right to pray inside the innermost area of the Sabarimala Temple. The Supreme Court today has referred this to its constitution bench, the matter which is pertaining to the ban on the entry of women at this historic temple. A three-judge bench which was headed by Chief Justice Deepak Misra framed several questions to be dealt with by the constitution bench. The five-member constitution bench includes whether the temple can actually restrict women's entry and on what basis. The apex court has also framed a question whether restricting the entry of women at the temple was actually violative of their basic rights under the constitution. It further added here that the constitution bench now will deal with these questions pertaining to this case. We have with us our senior correspondent on these legal affairs, Meenakshi Bhanja, with those inputs here. Meenakshi, this clearly being referred to a larger constitution bench. What are we expecting next?
Well, Seher, one thing is certain that the Sabarimala Temple ban issue is, one, not going into cold storage. Secondly, is going to be decided in a very conclusive, effective manner in such a way that it is going to be the final word on temple banning women issue in a very long time to come. And that is the reason this constitution bench reference assumes import, because as Mirror Now viewers will recall, in thorny contentious issues, what usually happens is, if it is a two-judge or a three-judge bench that has delivered a verdict after conducting the procedure of hearing lengthy arguments, in spite of the matter having attained finality or quietus, often those interveners or parties who are unhappy or dissatisfied with the outcome of the judgment often do not accept it, or they keep challenging it in petition after petition, whether it is a review petition or a curative petition or seeking a larger bench petition. Even after the matter has attained finality, the procedure continues. In order to curb all that, and also because, this is a huge issue, this is an issue which involves constitutional provisions, interpretations. And the Supreme Court at the outset has accepted the demands that were coming in when the original three-judge bench was seized of the matter and was hearing this petition pertaining to women entry ban in the Sabarimala Temple. In order to curb all that, today the Supreme Court has gone ahead and referred the entire question of the constitutionality of allowing this ban to continue to a larger constitution bench.
All right, Meenakshi, given the fact that sometime last year there was a historic decision that had come in on the same issue, this of course pertaining to the Shani Shignapur temple there in Ahmednagar in Maharashtra, that judgment was to have a very significant bearing on this judgment on Sabarimala.
Well, sir, that was an interesting judgment in itself. The Shani Shignapur issue also raising quite a few, flutters in the past. But remember, this is the Supreme Court of India. The Sabarimala Temple issue is perhaps a little more complex. Of course, the parameters of arguments which the temple board of Sabarimala is presenting before the Supreme Court is also pretty much along the same lines. But here, in the Sabarimala Temple issue, the temple board wants to tell the Supreme Court that the deity, the Lord Ayyappa, has a unique identity of his own, which is granted to him by the Constitution, that he is a celibate, and therefore women of a certain age group, from 10 years to 50 years of age, who are menstruating, are prone to disturb his celibacy, and therefore this is an essential matter of tradition and custom that has prevailed for centuries. It is accepted even by some sections of the women devotees of Lord Ayyappa himself, and therefore this is protected under Article 25 and 26 of the Constitution. Now, this is one very significant constitutional provision whose validity needs to be tested, and in order for that to happen, it has to be the Constitution bench of the Supreme Court of India that eventually hears these arguments, deliberates upon the finer nuances of the law points that are advanced before it, whether Lord Ayyappa has a separate, unique identity in the constitution where he is allowed this protection. Where
okay, so can an exception really be made on that front? Yes, Meenakshi, please stay on with us. Let's get in a word here from activist who's of course been a very vocal voice on this very issue as well. Rahul Ishwar with us over the phone line. Rahul, thanks for being with us. Your view on this development that has taken place today?
It's a victory for us. I'm personally in one of the petition and respondent in this case, Ayyappa Dharma
Yes.
Sena. It was on the request of Travancore Devasam Board, Ayyappa Dharma Sena, that this decision came. We are happy about this decision. We want the case to be fought on constitutional as well as cultural framework. We hope we will be able to put forward our arguments, and Ayyappa Dharma Sena will be touring Tamil Nadu, Andhra Pradesh, Telangana, Karnataka, to persuade the devotees, to inspire their government, to put forward a defense in Supreme Court Constitutional Bench, as CPM leftist government of Kerala is not supporting us. This is a victory for faith, and please remember, lakhs of women already enter Sabarimala. There is no female discrimination. There is only age regulation. We hope we will be able to point all these out in Supreme Court, and we will be able to win a favorable verdict for us. This is a faith of crores of people over past many millenniums. You cannot just change the...
Rahul, on what basis? Help us understand the arguments from your side, your team, that would be taken ahead here on this. On what basis this should really be taken as an exception as far as the Sabarimala case is concerned, because there were two other cases which were fought successfully as far as the Haji Ali Dargah, the Shani Shignapur temple case as well, where women eventually got the right to enter the innermost area of the temple. On what basis would you be arguing for that exception to be made for just Sabarimala?
There are 3 points. One, let us please remember that lakhs of women already visit Sabarimala. There is a lady Sabarimala in Kerala, which is in Guinness Book of World Records for the largest congregation of women. That's called Atigal. There are no men enters. In the same way, in Chakulathagawa, Lady Sabarimala, Nari Puja is done where no man offers Pongala. In a similar tone, if I can point out, this is simply like a male's educational college and a female college. These are two systems. We don't believe in discrimination, but differentiation is in nature. So puja readis or rituals are all set in that matter. And second point, this is a very deeper philosophical point, that inside temple there is no God. What is inside the temple is called a deity. God is not our concept. We believe in gods and deities. And deity system has been in India, ancient Egypt, Rome, Greece, and all the nations of the world. This deity concept is thousands of years old, and deities have specific rules and regulations. And third point, temple is not a public place. Temple is a private space of the deity for public worship. We have been successful in pointing this out in Supreme Court. Our advocate V.K. Baiju has very forcefully argued this case. We hope we will be able to point out such nuance.
Arguing this, saying that they're not allowed in the innermost area where the deity presides.
Exactly, and one more thing.
Why not?
Nobody is allowed in the area. Nobody is allowed. Not even males are allowed in the area where deities, innermost chambers of the deity is present. Where only priests are allowed. No, my grandfather is a supreme priest of Sabarimala. Only supreme priest and some 3 or 3 assistants are allowed. And here the fight is not to enter the sanctum sanctorum, but to enter the temple itself. Every temple has its own specific rules and regulations, and these are protected under Article 25 and 26. This is not a gender right issue. This is not a female right issue. This is a much more deeper fight between Article 25 and Article 14. Article 26, freedom of faith, versus Article 14, equality. We want to have a balance between Article 26 and Article 14, and we hope Constitutional Bench will be culturally sensitive to hear these matters.
All right, of course, hoping for the Constitution Bench to be culturally sensitive to this matter. At the other end, of course, women essentially fighting this under the ambit of fundamental rights to be allowed to certain areas of the temple. Rahul Ishwar, appreciate that word there coming in from you, saying that their side of the argument would resonate perhaps with the 5-member Constitution Bench to which this case has been referred to. We're going to be getting in several more reactions here on this, but largely being seen as along the lines to a similar fight of what has already played out in the country earlier this year, having met with much success with women rights activists and groups, particularly the Bhumata Brigade there as well, which was fighting for the right to women inside the innermost area of the Shani Shignapur temple of Ahmednagar in Maharashtra, also to an extent at the Haji Ali Dargah there in Mumbai as well.